Hello, everyone, and welcome to today's CMAA webinar. My name is David McCabe, and I'm the Senior Director of Education for CMAA, and I'm here at the CMAA headquarters in Alexandria, Virginia. Before we begin our presentation today, I have a few brief announcements. The first announcement is to participate now in the 2018 CMAA Finance and Operations Survey. Like last year, CMAA has contracted Industry Insights, which is an objective, independent, third-party research company, to collect and compile the results. On average, the survey should take approximately 1 or 2 hours to complete. Participants can save the data as they go on or download an Excel spreadsheet to upload into the system. Past participants will be able to copy over some general information from the previous year. Participants will also receive a complimentary copy of the industry report plus a customized club performance report with your own club's financial and operating statistics reported alongside the appropriate industry benchmarking comparatives. Club Resource Center subscribers who participate in the survey will also receive access to an online portal for interactive industry benchmarking comparatives. The deadline for participation is April 13th of 2018, and you can visit cmaa.org for more information. So if you have any questions for our presenters today, please type them in the Q&A box, which is on the bottom right-hand portion of your screen. Both Bill and Alyssa will be addressing questions at the end of the webinar, but please feel free to submit your questions at any time. If you are having difficulty hearing the presentation over your computer speaker, there may be a problem with your internet connection. If that is the case, you can also call this phone number, 415-655-0001. The number again, 415-655-0001, and enter the event number, which is 663-270-617. That's 663-207-617. I will be posting that information on the chat box, which is on the middle right-hand portion of your screen. But also, if you don't see that or if you're having difficulty finding that, you can always type in the Q&A that you're having difficulties hearing, and I can respond privately with the appropriate call-in number and the event number. The archive of today's webinar will be available on CMAA University, usually within 7 to 10 business days. Everybody who is registered for today's webinar will receive an email when the archive version is available. Now I'm pleased to introduce our speakers, Bill Wright and Alyssa Levy from Sherman & Howard. Bill Wright is a member in Sherman & Howard's Labor and Employment Department. For over 20 years, he has been studying and developing expertise in areas of the law that affect human relation operations. He advises employers on a daily basis with regard to employee relation issues, including discipline, reductions in force, and accommodation issues. He assists employers in developing policies, training, and standard procedures necessary to align worker conduct with employer goals. When employers require help with administrative agencies such as the EEOC or similar state agency, Bill leads the employer's defense, and when litigation develops, he is involved at every stage: pleadings, discovery, briefing, trial, and appeals. Alyssa Levy is an associate in Sherman & Howard's Labor and Employment Department. Her diverse practice includes representing clients in workplace safety and other employment matters. Alyssa advises employers facing discrimination charges and accommodation issues. She also assists employers in defending OSHA citations, advises on safety and health compliance, and defends employers in wage and hour claims, including FLSA collective actions. Prior to joining Sherman & Howard, Alyssa focused her practice on workers' compensation litigation and on defending employers in personal injury and toxic tort lawsuits. She has experience representing employers in trial, arbitration, mediation, and settlement conferences. So I'd like to introduce to you Bill Wright and Alyssa Levy. Bill and Alyssa, I turn it over to you.
Thank you, David. This is Bill, and Alyssa is with me as well. And if you all have any trouble hearing us, I encourage you to say something in the chat box to David, and we'll try to fix it as quickly as we can. Thank you all so much for joining us this afternoon. We really appreciate the opportunity to talk to you about this issue. It's a very timely issue, and Alyssa was telling me earlier that she'd received a client call about this just today. So our project today is to talk about accommodating marijuana use. I assume that some of you will be in states where this is a pressing issue, and some of you will be in states where you think that you're immune from the issue. Part of our goal here today is to talk about how employers all across the country can set up their policies to find a safe harbor around various kinds of legal complications that arise around the increasing use of marijuana by all of our employees. As David mentioned, Alyssa and I are associated with the Labor and Employment Department at Sherman & Howard. Sherman & Howard is a approximately 200-lawyer firm with headquarters in Denver, Colorado, but we have offices all over the country, including a large presence in Arizona, and our colleague Robin Stoll is probably online with us listening in and judging us as we speak. And then we also have a labor and employment presence out in Georgia as well, for those of you who are on the East Coast and want to contact somebody who's a little more local. So with that, I'm going to turn it over to Alyssa for the first stage of the discussion, which is going to focus on aspects of federal law that apply to marijuana use. I'm going to change the slide, and then I'm going to pass the baton to Alyssa.
Perfect. All right, so we want to start out with the basics of accommodations. And there's really two sets of laws that guide workplace accommodations, the Americans with Disabilities Act and Title VII. So first, under the ADA, this protects employees with a disability. And for an accommodation of the disability, there must be a substantial limitation on major life activities, even when using a mitigating measure. And the limitation must affect the employee's ability to perform essential job functions. So if both of these are met, the employee can get a reasonable accommodation. And you may be familiar with this language, so briefly, this is a reasonable accommodation. It's just a change or adjustment to a job so that the employee can perform their job duties. So if an employee tells you that they need an accommodation, or they come to you and say they have difficulty carrying out their job duties because of a disability, determine what their job duties are and how those can be accommodated. So the interactive process is working with the employee to determine an accommodation for their disability that works for both the employee and you as the employer. So now we turn to the basics of accommodations under Title VII. You may be familiar with Title VII as protecting employees on the basis of their race, sex, color, national origin, and religion. There is a specific provision for accommodations under Title VII for religious beliefs and practices. If religious practices conflict with work duties, the employer must suggest an accommodation before taking disciplinary action. So for example, this one is very basic, but I think you get the idea, changing an employee's schedule so that they do not have to work on a religious holiday. So an employer must accommodate an employee's religious beliefs and practices unless there is an undue hardship. So that is the language that Title VII gives us. But keep in mind that courts often consider any burden on the employer to be small or de minimis, you could say, no matter what lengths the employer has to go to for accommodating an employee's religious beliefs. So now we want to look at accommodations as specifically applied for marijuana. Now, under the ADA, there is no coverage for an employee or job applicant who is currently engaging in the illegal use of drugs when the employer acts on the basis of this drug use. And the words currently engaging are key to this statement under the ADA. Now, the ADA further says that it is the employer's choice whether they prohibit the illegal use of drugs and alcohol at the workplace. So this is the language that the ADA gives us. And one thing that we wanted to mention was how to deal with addiction under the ADA for any employees that may be current or former addicts. An employer cannot discriminate against addicts because of their history of drug use. They cannot claim that there's a foreseeable relapse that will happen or treat them any differently if the employee is in AA. The same standards apply for addicts in terms of on-the-job impairment. Addicts who are qualified individuals under the ADA still cannot currently be using drugs. So now under Title VII, this is a little different, the analysis that you do. Under Title VII, an employee must show that there's a work rule in conflict with their religious beliefs. The employer knows of those beliefs, and the employer takes adverse action without accommodating the employee's religious practices. So we came up with a prime, you could say, almost an extreme example, but I think it's a good example of illustrating this under Title VII. The Church of Cannabis is a church that started in Colorado, and these are popping up all over the United States. And this is a religion that's based on self-discovery through marijuana use. So even though the ADA prohibits currently engaging in marijuana in the workplace, Title VII says that you cannot discriminate on the basis of religion. And the Church of Cannabis says that marijuana use is their religious practice. So under Title VII, an employer cannot discriminate against an employee who claims their religion is marijuana use. So you can see the conflict here between ADA and Title VII. This is similar to prior cases regarding peyote use. You may remember that. In those courts, they often said that the employer may still be unable to accommodate someone's religious practice, though, if their drug use is posing a safety issue. So I think a lot of the cases seem to hinge on safety issues. For example, if an employee's job requires driving, you cannot accommodate marijuana use for a driver. So the Church of Cannabis is a unique example. You could call it an extreme example, but Title VII claims are not as prevalent as state law claims. So before we discuss application and interpretation of marijuana by the states, we wanted to show you a map of which states have actually legalized marijuana. So here you can tell by the color coding and those numbers on the right that 30 states have legalized use of medical marijuana, 9 allow use of recreational, which also includes medical marijuana, and 16 states allow cannabidiol, which is oil or candy that's used to treat pain or severe conditions such as epilepsy. So now we want to get into the state law issues. And I'm going to pass this to you, Bill.
Okay. So many of you who are thinking that you're in a state like Georgia, for example, where marijuana is supposed to not be legal, may be surprised to see that actually medical marijuana in some form is legal in your state. It's really only 4 states where there's not any state law saying that there's a right to use marijuana, or at least it's not illegal under certain circumstances. But I wanted to take a minute and talk about a particular case that came up in Massachusetts, and this is from July of last year. You may have noticed it. It may be the reason that many of you joined this call. This is the Barbudo versus Advantage Sales case. So Ms. Barbudo got a job working in a grocery store handing out samples. Some of you may have seen people working in the grocery stores handing out these samples. And just before she started, they explained to her that she was going to have to submit to a drug test. This is an employer that does pre-employment, post-offer drug testing. Many of you may do the same thing. It's expressly permitted as a medical inquiry under the ADA after you've made somebody an offer, but before they start, you can subject them to a medical examination, including a drug test. So they did this for her. She immediately contacted the person who was hiring her and explained that she was going to test positive for marijuana. She had what passes for a medical marijuana card in Massachusetts. And she had been using marijuana to treat her Crohn's disease and IBS. As every employee does, she makes explicit the point that she never uses it at work or even before work. She's never impaired at the job, but she does use marijuana on the weekends to treat her pain and other symptoms. And the manager she was speaking to about hiring her said, went off and checked with the boss, of course, and then came back and said, yeah, testing positive for marijuana in that way is not going to be a problem. So she submitted to the test, they took the sample, they ran the test, she started work, and after her first day of work, Human Resources called her up and said, no, you can't work, you tested positive for marijuana, we're going to let you go. You can imagine that this was not a popular decision. She didn't like that outcome at all, and naturally she sued. All of my stories end up with, and then she sued. She sued under Massachusetts state law. Now, Alyssa's just been telling you about federal law, both the Americans with Disabilities Act and Title VII, and giving you applications of those things, but this is a suit brought under Massachusetts state law. The outcome of the lawsuit, well, first of all, I should mention that the lawsuit was both against the employer and against the human resources representative. Many of the state laws, including the Massachusetts law, permits a lawsuit against managers, including HR managers, who are aiding and abetting the violation of the statute. So although we never get supervisors sued under the ADA or under Title VII, can happen in state law, that a supervisor or an HR manager will get sued. And that's what happened in the Barbudo case. The Barbudo case is against both Advantage Sales and the HR manager who delivered the bad news. Well, the case goes to the courts, and the courts determine at the first pass that there's no violation of the Massachusetts Medical Marijuana Act because no accommodation of her use of medical marijuana was possible. The employer had a policy that prohibited testing positive for marijuana. She tested positive. She was in violation of the policy. Any accommodation that would have required the employer to let her work while testing positive for marijuana would have been absolutely unreasonable. Unreasonable as a matter of law because it would have violated the ADA. That was the determination of the court at the lowest level. The case was dismissed out of hand because no accommodation would have been possible without violating the ADA. Ms. Barbudo appealed, and the case went to the Supreme Court of Massachusetts. And as you can tell by the fact that I'm telling you this story, that the determination was that it might be possible to accommodate somebody in the use of medical marijuana. Despite what the ADA says, it might be possible. And the 2 points that make this possible in Massachusetts are points of specific Massachusetts law. First one is out of the Fair Employment Practices Act in Massachusetts, which is the state equivalent of Title VII and the ADA, and it says that any person diagnosed with a debilitating medical condition has a right to accommodation. This is an important way of wording this, because the Massachusetts Medical Marijuana Act then builds on that by saying that patients in Massachusetts who are using medical marijuana shall not be denied any right or privilege on the basis of their medical marijuana use. You can see how the court would put those two things together. There's a right to accommodation, and you can't be denied the right because of medical marijuana use. Defined in Massachusetts, a specific state law right to an accommodation even if you're using medical marijuana. I want to point out a couple of things that the court in this case said because they're significant for our understanding and our obligations as employers, sort of wherever we are. The first is sort of a general point about disability accommodation or accommodation of medical conditions sort of generally. And the first is that if you're an employer who has a policy prohibiting the use of a medication, opiates, for example, you don't want people who work for you to be under the influence of painkillers. And you have that general policy, and an employee comes to you and says, I'm testing positive for that medicine. Ordinarily, if that medicine is being used to treat a disability or an underlying medical condition, we would expect the employer to engage in the interactive process and to have a discussion with that employee about whether there's some other medication that they could be using that would not trigger the positive test result, that would not be in violation of the employer's policy, but that would be effective in treating the underlying medical condition. So for painkillers, if you've got somebody who comes and says, hey, I'm taking painkillers, and it's preventing them from complying with your workplace policies, we would ordinarily expect there to be an interactive process and a conversation with the employee in which the employer says, well, can you switch to something else? Because, painkillers, they really interfere with your concentration. Can you use something else that would allow you to control your pain and not impair your function on the job? And they'd go back to the doctor and see if there'd be some alternative medication that could be used. And that's the first point that I wanted to say, that Barbuda Court really pulls out of ADA law, essentially. Ordinarily, we would expect there to be some discussion about accommodating a medication. The next point is that the Massachusetts Medical Marijuana Act did not require any accommodation of on-site medical use. Remember, this is a woman who was not using the medical marijuana on the job. She used it after the job, after the job, but would still test positive in the course of medical drug test. The next point, then, is that the employer argued, and the court below agreed, that using medical marijuana, rather possession of medical marijuana, violates federal law. And somehow that was supposed to make it clear that there is no obligation to accommodate medical marijuana, and that any attempt to accommodate medical marijuana would be in violation of federal law. The court points out the employer doesn't violate federal law when the employee is using marijuana. The employer is not at any risk at all. So it's not related to the federal law in the way that a violation of federal law would be. Clearly, it would be an unreasonable accommodation to require the employer to violate federal law. Requiring an employer to accommodate medical marijuana use does not require the employer to violate federal law. And then the final point about Barbuda is this issue with regard to whether it's just always unreasonable to expect an employer to accommodate medical marijuana when the employee's use is in violation of federal law. And here the court's answer was, I think, really illustrative of a development in the consciousness of medical marijuana use and even recreational marijuana use in the United States. And the court noted that nearly 90% of the states allow some form of medical marijuana. And if you're going to say it's just unreasonable to allow people to work even though they might test positive for some amount of marijuana in their system, you're essentially saying that those states, all those states, are not being reasonable. And the Massachusetts Supreme Court was not willing to say, as a matter of law, that there's just no reasonable way to accommodate medical marijuana. So the effect of this ruling from the Massachusetts Supreme Court was to send the case back to the trial court to continue the processing, to say to the employer, well, we think you should have some interactive process with the employee about their medical marijuana use, whether it impairs them, whether it affects their ability to do the job, and how else they might treat their Crohn's disease so that it doesn't violate your policy. The court did not say, we think it's obvious that there is a reasonable accommodation. The court did not say all employees have to be allowed to come to work under the influence of medical marijuana. The court did not take a position whatsoever with regard to whether there was, in fact, an accommodation available in that case for that person doing that job. All the court said was, we can't rule it out as a matter of law. Still, the case came as a big shock to those of us who follow these things, and we were really concerned that it was going to be the first salvo in sort of an ongoing evolution of the law around this issue that's going to require employers to accommodate medical marijuana use. Again, let me emphasize that medical marijuana use and the obligation to accommodate medical marijuana use is a state law issue. As you look around the country, you will see various different states have different standards that have been put in place around this issue of the need to accommodate medical marijuana use. Colorado very specifically adopted a provision that says employers have no obligation to accommodate medical marijuana. It's built into that piece of the law that made medical marijuana use not illegal. This is all very carefully worded in the law, right? Not illegal under Colorado law. And Colorado has enforced that, even to the point of having a Colorado Supreme Court case on the issue of whether employees had the right to use medical marijuana off work and come to work without being impaired with a trace in their system. And the Colorado Supreme Court determined that no, the medical marijuana law in Colorado did not create a right to have medical marijuana in your system. Right? And it did not restrict the employer's right to prohibit any trace of marijuana in somebody's system. So Colorado is a very strong state with regard to employers' rights on this subject. Arizona, not so strong, because Arizona's state statute on the subject says that you may not discriminate against employees on the basis of their status as a medical marijuana user. California's new recreational statute is a little vague as to what employers can do, but the medical marijuana statute was a little clearer and provided the employers a defense. It is not clear to me, looking at California's new recreational marijuana statute, that you may, in California, take action against somebody simply for testing positive for residual amounts of marijuana in their bodily system. So it's a state law question. In general, you ought to, if you really want to get to the bottom of whether there's an actual obligation to accommodate, you're going to want to look at the state law and maybe even some local laws. What we're going to present here in a little bit, though, is sort of a generally acceptable list of things you can do and find yourself relatively safe. So I'm going to turn this back over to Alyssa for a second.
Thanks, Bill. So now we've looked at some state court issues. Now we want to look at the federal court treatment of marijuana. The federal courts, from what we've seen, are not joining the state's embrace of legalizing and accommodating marijuana use. So in this first case that we have up here, Lambden versus Marriott Resorts, the employee was a groundskeeper, and he had a medical marijuana certificate to use medical marijuana for his hip pain. He was reprimanded at work one day for a task, and because of this reprimand, he had a panic attack and had to go to the hospital. Now, the employer had a policy to drug test any employee when they have an on-the-job injury that requires outside medical treatment. So when this employee went to the hospital for his panic attack, he was required to take a drug test, and he tested positive because he had been using the medical marijuana outside of work for his hip pain. But on the basis of his positive drug test, he was terminated from his employment. So the court said in Lambden that a drug-free workplace may prohibit the use of illegal drugs by its employees. And they cited the ADA, which says that the ADA does not protect an employee from retaliation if he is currently engaging in the illegal use of drugs and the employer acts on that use. So here we're seeing that language, currently engaging, again, that we looked at the beginning of the presentation. So just because a state legalizes marijuana, employers are not required to accommodate marijuana use because it's still unlawful under federal law. So we would give you a word of caution to beware of evolving statutory language as the federal courts continue to interpret the conflict between state and federal laws. Bill, I think you wanted to discuss Terry.
Well, I did, and it's because there's another issue with regard to the evolving statutory language. It's one thing to say that whether you have an obligation to accommodate marijuana use in an employee is dependent on whether the case gets brought in federal court or state court. It's kind of the way it looks at the moment. Some state courts are going to be danger zones, and the federal court is a safe spot. And what you really want to do is drag everybody into federal court if you can. As a side note, they tried that in Barbuda. Right? They brought that claim in state court, and the defendant tried to take it over to federal court in a process that's called removal, probably on the basis of ADA preemption or something like that. And the court refused. It was a strictly state law issue, some state law right to privacy, state law statutory versions. It belonged in state court, and it stayed in state court despite the employer's attempts to move it to federal court. You don't always get to choose which court you're going to be in. And the Terry case is, I think, even a little more scary. Some of you may have been following the developments in the 7th Circuit and 2nd Circuit and the 11th Circuit with regard to whether Title VII is going to end up protecting people on the basis of their transgender status or their sexual orientation. And we've been seeing these federal courts go back into Title VII law and reverse interpretations of the law that have been in place since the 60s, certainly since the 70s. And the courts are saying things like, well, we need to allow our understanding of the words in Title VII to evolve. So while sex in 1970 meant biological sex, now it means, adopted sex, any sex, change of sex. Anything that has the word sex in it is, counts as sex. And the Terry versus UPS case is taking those precedents from the federal court saying that the nature of statutory language evolves and is beginning the process of trying to get the courts to recognize that the language in ADA ought to evolve as well, and that medical marijuana ought not to be seen as an illegal drug use. Remember, Alyssa's been telling us about the federal standard that you don't have to do anything with regard to currently engaged people who are currently engaging in illegal drug use. But we find now that and I start having a push against the courts, trying to get them to recognize that engaging in medical marijuana use in a state that permits it is not going to be current use of an illegal drug. Okay? So Alyssa, why don't you flip us onto the next page there. So what's causing all this problem, all this disarray, I think, in the law having to do with employees' use of marijuana is really a technology gap. It's really that we're not in a position to test whether somebody is currently impaired by marijuana use. And compare it to alcohol. If we have an employee who's involved in an accident, or an employee who's injured on the job, or an employee who's behaving erratically, and we send that employee out to be tested, and they come back with a certain level of alcohol, we know that they were impaired, and that accident is their fault, and we're going to fire them for it. We have a test for alcohol that more or less directly relates to the level of impairment. The more alcohol, the more they're impaired. But the test for medical marijuana, or indeed the test for marijuana generally, doesn't do that for us. We send somebody for a drug test and it comes back positive for the derivatives of marijuana in the system, THC, and it might come back with a very high level of THC, and that does not really correlate to whether that employee was recently impaired. They might have levels of THC that are quite high and not have any impairment because they're accustomed to it or because of their size or for biological reasons that I can't explain. So the drug test alone doesn't allow us to conclude that the person was impaired on the job in a way that an alcohol test would, or even in the way that a test for opiates would. The consequence of this for employers is that we cannot just mechanically rely on sending somebody out for a drug test and use that as a proxy for whether that person was impaired on the job. And it really is impairment on the job that ought to concern employers most. Employers are not really in a position of being responsible for enforcing federal drug law over state drug law. We're not really responsible for what employees do on their own without the presence of a coworker over the time when they're not at work in the privacy of their homes, and we're really not the drug police. What we really care about is that employees not harm the employer's function and the employer's operations and not show up to work impaired and not smell of marijuana, not act as though they are high, and be able to provide our clients and our customers with the service that we require. So what I'd like to suggest is a way of structuring the employment policies and training and procedures so as to focus most directly on the employer's legitimate interests, less on issues of federal drug law versus state drug law, so that we can get on with our business as businesses. Okay? So the first stage that I want to suggest to you all is that you should have a look at your policies. You may, under, I think, any of the state laws, any of the federal law, you may have a policy that absolutely bans employees from using marijuana and indeed any drug on site, and absolutely positively bans any impairment as a result of any medicine, any drug, including marijuana. I've written any number of these policies. You just have to be very explicit about what it is that they may not do. And you want to make it clear that they may not be impaired by any amount of alcohol or any illegal drug, and then I usually call out marijuana specifically because there's getting to be this understanding among marijuana users anyway that marijuana is not illegal in these various states. You call out marijuana. You may not come to work and use marijuana. You may not be impaired at work because of marijuana or any other drug. And you may absolutely, positively have a policy that bans any possession of marijuana on site. We've got a case going on in our office now where the employee got fired for having a great big bag of marijuana. Just moved to Colorado and was fascinated by the concept of being able to legally buy marijuana and bought several ounces of marijuana and brought it to work and had it in their locker and got fired. You may have a policy that says don't bring any of these substances to the work site. And then crucially, I think, for our purposes, you also want to have a policy that creates and upholds very strong professional appearance and hygiene standards. You do not have to put up with employees coming to work reeking of marijuana any more than you have to put up with employees reeking of alcohol. You don't have to put up with them dressing in a disheveled manner or any other issue that makes it seem as though they are anything other than a sharp, appropriately attired customer service representative. And I encourage you to set the policies in terms of those kinds of standards. What we care about is observable impairment, possession and use, and the ability to actually provide the customer service that we're requiring. And the next step, after making sure you've got those policies in place, is to focus on the job descriptions. And we'll see why here in a little bit. But I would encourage you to give some thought for each job description as to why it is that that particular job requires somebody to be at the top of their game and sharp-witted and not impaired by painkillers or marijuana or alcohol. Give some thought as to why it is that it's important for that job to be someone who is at the height of their professional capacities. And build that into the job description, not necessarily explicitly saying you may not be impaired, but making it clear that the job duties require concentration, require the ability to handle inquiries from our customers and our clients and be able to respond appropriately and to analyze and to do important thinking on the job. And also whether the jobs are safety sensitive. So if we've got groundskeepers who are supposed to be operating heavy equipment, we've got small bulldozers or bobcats or large lawnmowers or whatever it is that we've got that the employees need to be operating, we need to build into the position descriptions that these are safety-sensitive jobs. And this will become clear in just a moment.
So also to add to your to-do list is to identify evidence of at-work impairment through your managers. So you want to make sure that your managers are trained so that they can identify certain behaviors of your employees. And active management plays a key role in identifying impaired employees. So if a manager knows their employees and checks in with them every day, they're familiar with them, they can better identify any changes in their appearance or violations of your hygiene policy. If they are abnormally disheveled, or if they are, if they're just not looking like themselves, a manager who knows their employees can identify these changes. They can observe the employees while they are working, and to add on to what Bill was just talking about with safety and risky behavior in certain jobs, if an employee is acting notably different than usual, a manager who knows their employees will notice this. A good manager can tell if an employee is just tired in the morning, or they had a big lunch so they're sluggish in the afternoon, compared to them actually being intoxicated at work. So be proactive in your management style to identify risk factors before an accident occurs. That's the whole point of having this to-do list, so that you can identify risks before something happens to either a customer or to one of your employees. The second part of manager training is to train someone on making decisions on when it's reasonable to give a drug test. This can be the manager who's in charge of the employee, or it can be someone else, just as long as someone there is trained on how to make the decision of when it's reasonable to give a drug test to an employee.
Hey, can I jump in just for a second, Alyssa, and make a connection here? Because the important thing, from my point of view, to understand about why it is that this aspect of management training is on our to-do list, it goes back to that diagnosis I gave, right? It's that we can't really rely on the test. We can't just send somebody for a test and find out if they were impaired or not. What we really need under a bunch of the different state statutes is to be able to tell whether the person is impaired by observation. I talked a little bit about the Terry case and how the talk around the Terry case was that the lawyers involved were trying to force the courts to update their understanding of the ADA. Well, the facts of that Terry case were a very typical situation that employers find. The employer says, we observed this office worker and their speech was slurred and they seemed to be impaired, and that's why we sent them for testing. The testing gave us a trace of THC that confirmed our observation. And based then on both the observation and the drug test, we took action. Those are the underlying defenses that are being brought by the employer in that Terry case. It's a very typical scenario that we see. And I think it's a much more defensible position for all of you to have, to focus not just on, that person tested positive, we're going to take action, but we watched this person and they were driving the lawnmower all over the greens and scaring the clients. We talked to this person. Their speech was slurred. They weren't focused. They smelled of alcohol, or they smelled of marijuana. All these kinds of observations are important. You don't need to have a medical degree to make those kinds of judgments. It is helpful if you've got someone who's been through training to know what to look for. I myself have missed indications of drug use in managers when I've been doing investigations, and I think it's helpful to have an appropriately trained person on staff who can chime in. Maybe not for the reeking of marijuana. We can all tell when that's happening. But being able to tell just from a conversation whether the person is impaired or sluggish, that might be a real advantage. Back to you, Alyssa.
I think we're on to the next slide.
Okay, which is back to me. Okay, well, so having in place then your policies with regard to on-site drug use and possession and impairment and professional standards, the next stage of review that you want to think about are sort of more general policies. They're not just aimed at finding people who are impaired, but at sort of more protective policies around both your compliance with the ADA and the FMLA and other similar statutes. So it is useful to have a procedure in place where employees are required to report to Human Resources if they have been prescribed a medication that is likely to impair their function, and give you a chance to get ahead of the curve. Find out that they've just been given a fentanyl patch and they're going to be coming to work under the influence of opiates. That's something you might want to know, especially if they're in a safety-sensitive position. Even if they're not in a safety-sensitive position, you might want to know that because you want to pay a little more attention to them, see whether they are in fact performing their job adequately, or if they are in fact impaired, even though the doctor said they wouldn't be. So you want to have that reporting process in place. They should be reporting if they have been using medical marijuana to you. I think you should have that conversation with them, and you should explain to them that they cannot be impaired under any circumstances. I think that spending a lot of your effort trying to track down people who have a trace of THC in their blood is probably not the best use of your time. Next, I think you ought to have a process for employees to formally request any kind of accommodation they might need. Now, that doesn't defend the employers altogether, because if an employee goes to their supervisor and says, hey, I've got a medical condition, I really need help with X, the supervisor has got to be trained to refer that to HR. The employee has made an accommodation request to a supervisor. We're stuck with that. The supervisor has to know when to call HR. But I think it is useful to have a policy out there that says to the employee, don't just go to your supervisor. Come to HR with those issues. Come to somebody who's trained to recognize the issue and trained to take steps to engage in the interactive process and figure out whether an accommodation is possible or not. And then if you're going to go to the step of having drug testing, you do need to check your local laws. There are various cities across the U.S. that have very special drug testing laws. And you want to make sure that you're aware of those before you implement a drug testing policy, excuse me. My suggestion is that your policy call for random testing really only when we're talking about a safety-sensitive position. We're not out to enforce federal drug law. We are out to enforce our professional standards of hygiene and appearance. We're out to enforce our standards of quality of work. We're not out to enforce whether somebody's got a little bit of THC in their blood system. So I would only do random testing if it's important to make sure that everybody stays perfectly sober because they're involved in a safety-sensitive position. I would actually expand that to various kinds of managers because the managers have a heightened level of responsibility for enforcement of the safety-sensitive positions. So and I don't want to insist too much that we restrict it to just safety-sensitive positions. I think we would expand it a little bit to people who have enhanced responsibilities of various kinds. But if we're talking about line employees who don't have any kind of safety-sensitive role and who are not managers, probably just sending them for testing when they smell marijuana or are behaving erratically is adequate for most of our purposes. And I think it's helpful in your drug testing policy to have medical review officers involved so that the employees have an opportunity to explain to a medical review officer why it is they tested positive for morphine because of their poppy seed muffin in the morning without that turning into a positive result that you need to deal with. So those are my suggestions for things that you all might put in place that I think would position you well to defend a disciplinary action or even a termination on the grounds of medical marijuana use and impairment on the job. So we want to give a few minutes here for an opportunity for you all to ask questions because I know that this is an issue that has been coming up more and more in recent months, and we want to be responsive to any specific questions that you might come up with, bearing in mind that we might say any particular question depends a lot on the facts, and that we would need to have more facts and may need to talk to you all offline about it later. If anybody has any questions, David, you might jump in and
sure.
Moderate for us.
The one question here, I think it goes to the slide right before this where you were talking about having employees come and mention any issues that may cause them there we go. I think the first, underneath the first bullet point there, they said, how would HIPAA rules apply there, or how would that affect HIPAA rules about medical privacy?
May I take this one, Alyssa?
Sure, go ahead.
Okay. So unless you all are in possession of medical treatment files for some reason, so if really you're a clinic or you're a medical service provider of some sort, or you're in the business of supporting those industries. So, for example, you're a law firm with clients who are medical clinics, or you're doing the transcription work for them, or some other kind of business associate, a covered entity. You're not really going to have any problems with those things. However, you're not really going to enforce this to the point of firing employees necessarily who fail to report a condition that isn't otherwise impairing them in any way. It doesn't really rise to a HIPAA issue. It's really squarely within the right of an employer to find out in advance whether an employee is currently working under any kind of impairment. You want to be careful about it, just like you would under the ADA. You don't necessarily want a lot of information about the diagnosis or the underlying medical condition, but you are entitled to know whether an employee is coming to work under the influence of a substance that is going to prevent them from doing their best work.
Okay. The next question says, if your company...
David, I just want to add real quickly onto that, that two of the cases that we discussed today, the Lambden case and the Terry case, in both of those, the employee disclosed to their employer that they had a medical marijuana card. So even if if an employee comes to you and says that they are a medical marijuana user, it does not prevent you from taking the normal course of action that you would if you found out later on that they use medical marijuana.
Okay, thank you. And actually, that might lead perfectly into this next question. It says, if your company currently has a zero tolerance policy for possession / absolute ban on usage, and a new hire discloses his or her usage, can we tell them they will not be hireable?
Well, again, Alyssa, shall I go first?
Sure,
okay,
go ahead.
Okay, you're texting me that I should go ahead. So this has actually been a serious problem for employers in Colorado. I'm resident in Colorado and as well as Arizona, and it's been a significant issue here in Colorado ever since we got medical marijuana and then recreational marijuana, because employers typically want to emphasize to employees that they need to not have any level of marijuana use whatsoever, and then when we do a pre-employment post-offer drug test, we discover everybody who comes in the door is testing positive for THC. It's not that they are using it on the job. It's not that they're currently impaired. It's that they've been unemployed for 2 weeks, and during that 2 weeks, they all lit up for a while. It's incredibly well distributed around the state. And we get a lot of that. And what the employers here have been having to do is to adjust their standards with regard to hiring. Right? So they meet with the employee and they say, well, you tested positive for THC. Going forward, that will be unacceptable. You may not work under the impairment of marijuana. Now, what I've been advocating in the list of to-do items is that we not emphasize too much the issue of whether the person tested positive for any level of THC, and instead that we focus more on active management and on trying to observe whether the person seems to be impaired in any way on the job or as they check in for the job or as they are engaged in any kind of safety-sensitive issues. And if that's the path that you follow, again, you would meet with the employee as they come in. You would say, you tested positive for THC. I want to emphasize to you that our standard policy is no use on the job, no impairment whatsoever. If we find that you are impaired on the job, you will be fired. And I virtually guarantee you that the employee will say, oh, no, I never use it on the job or even before the job. I only ever use it over the weekend. And so any test that I pop positive for is going to be a test that is just residual. You're going to have to monitor that employee and indeed all employees fairly carefully to make sure that they are not coming to work impaired.
And also on the slide that we still have up on the screen where Bill was discussing the drug testing, if you have new hires that understand that they can be subject to random drug tests at any time, you may have an easier time enforcing your no tolerance policy.
Yeah, absolutely. Somebody who's, especially in a safety-sensitive position, you're going to want to pay special attention to that. And you can, of course, treat anybody who is involved in an accident or injury on the job as somebody who has created a reasonable suspicion calling for testing.
Okay. We did have an interesting question come in. It's somewhat related to some stuff you talked about. They said, what suggested way do you send an employer to a drug test? Get them a car, have them walk if possible, manager go with them. So if you get to a point where you do have to send somebody for a drug test, what is your recommendation or suggestion on how to get them there?
That's a very good question. Because you certainly don't want to put yourself in a position where you have reached the conclusion that this is an impaired person. And so your next step is to put them behind the wheel of a car and have them drive someplace. That does not ring true. It's either going to be evidence that you didn't really believe it, or it's going to be evidence that you didn't really think they were impaired, or it's going to be evidence that you just didn't care about who they ran into on the way. So that's not going to be a good scenario. You're going to be much better off if you either put them in a cab or take them, have somebody take them to the drug testing facility. If you're going to have that kind of test, that kind of policy in place where you do that kind of testing, you're going to want to have some kind of contract with a relatively nearby lab who can do the work for you. And so you're going to want to have a place where you're going to be sending them and give that lab a call, let them know that they're coming. But you're going to want to make sure that they go in a way that is safe for everybody else on the road and reasonably assures that they arrive safely.
Okay. Well, thank you very much. I think that's all the questions. And we're coming up on 3 o'clock here. So Bill and Alyssa, thank you so much for your time today. We appreciate it. And for all of you that joined today, we appreciate that as well. We will be adding a couple more webinars to the schedule very soon, so please keep tuned, and we will have that information for you soon. So again, Bill and Alyssa, thank you so much.
Thank you.
Thank you all. Thank you for joining us this afternoon.
You're welcome. Have a great day, everyone.